Are you a self-storage owner or operator looking for service providers to help at your facility? Well, the Storage Business Owners Alliance, also known as the SBOA, has you covered. The SBOA is a premier online hub for connecting self-storage owners and operators to industry-leading products and service providers. We provide one-stop shopping for your business with exclusive offers to save time and money. At the SBOA, we believe by coming together, we help owners and operators grow revenue, gain purchasing power, reduce expenses, improve efficiencies, and increase profitability. We also offer many resources such as our conferences and self-storage unlock webinars to help self-storage owners and operators gain the knowledge needed to become more competitive in the industry. To become an SBOA member or to find out more information, please visit www.thesboa.com today. We can't wait for you to join the Alliance.
Good morning, everyone, and welcome to today's Self-Storage Unlocked webinar. I am Iris Czygan, president of the Self-Storage Business Owners Alliance, better known as the SBOA, and I'm excited to be your host for today's webinar. Before we dive in to the legal updates, I want to thank SBOA Insurance Services for sponsoring today's webinar. SBOA Insurance is a trusted partner in providing self-storage operators with the best tenant insurance and now commercial insurance options as well. Today, we are joined by two incredible legal experts who probably don't need any introduction whatsoever. We have Carlos Kaslow and Scott Zucker. Hi, gentlemen. How are you today?
Good morning.
Hi, Iris. How are you?
Great. It's good to see you. If you want to tell everyone a little bit about your background in self-storage, obviously you're great attorneys. There's very few people in the industry who haven't seen you speak, but let them know about you. And I also want to tell everyone about your self-storage legal network.
Okay, well, as far as I'm concerned, I've been around for too long, probably, 1979. And through the 80s, 90s, and beyond, I had the pleasure of being the general counsel for the Self-Storage Association for 2 decades and founded the Self-Storage Legal Review, which was a legal newsletter that's now published by the SSA. But it's been a nice ride, and I've really enjoyed being part of self-storage. And I think in some ways it's truly a unique industry.
Definitely.
And I'm Scott Zucker, and Carlos is being modest, as he often is. I'd like to call him the Dean of Self-Storage Law. For those of you in the self-storage industry that bother to read your laws that govern your business, Carlos had a lot to do with preparing those and creating the instruments of how you operate your self-storage facilities. So it's been a pleasure to work with Carlos over the last 25 plus years as part of the Self-Storage Association and the Self-Storage Legal Network, which was something that Carlos created over 25 years ago to service operators who have a need for legal information to support their operations. Myself, I'm a commercial litigator based out of Atlanta, supporting self-storage operators in the elements of their business from construction to employment to operations. And it's, as Carlos said, it's a great industry, and we've enjoyed servicing our clients for now, going almost 40 years.
That's fantastic. And you both do such a great service to the industry, providing so much education, information for everyone. And the Self-Storage Legal Network is just one more amazing extension of that to help everyone in the industry stay compliant and stay out of trouble, and just help us cope with some of those issues that arise in the business. Before we get started real quickly, I do want to tell everyone we are giving away a $20 Starbucks gift card today for our most active participant. So make sure that you are asking your questions, get them answered from the experts live today while we have them here. And we will also have a few polls throughout the presentation. Please let us know who you are, where you're from in the chat. Answer the polls in the chat and ask all of your questions in the chat. And we'll try to get to all of them today. And so with that, we will just go ahead and dive into our first topic, and that is rent control and pricing issues. So in light of the changing landscape around rent control laws, can you guys tell us, what are these protection plan rate increases? How do they work? Whether they are subject to the same limitations as rent for storage space? How is it different for tenant protection versus tenant insurance? Give us the lowdown.
Well, California right now, there is a bill pending that wouldn't just be a limitation on increases during emergencies. California is actually considering a self-storage rent control bill. And essentially, if it is enacted, and probably better than 50-50, it would limit annual increases to 10%. And as far as I know, I believe this would be not just the first rent control bill that would actually impact self-storage. It would be really the first non-residential rent control bill enacted by any state. It's been a area that's been visited, but it's never gone through. I think the type of control on rent most people are probably familiar with are the price gouging statutes, which do limit increases on rent and a whole panoply of services and products while the emergency is in effect. And we've seen those occur around the country. And, right now, the LA County is in the midst of such a restriction on self-storage rents. And right now, it appears that in California has what we call a hard limitation on price increases. And what the statute essentially says that you can only increase rents up to not more than 10% of what it was prior to the declaration of emergency. And the one in LA right now is set it will not expire until January of next year. So it looks like it's going to be, rents are going to be under control for a while within Los Angeles County with respect to self-storage. And in a nutshell, if you're doing protection plan, it's a little bit different than insurance. Protection plan is from an operator to tenant standpoint, the operator merely charges additional rent for essentially not enforcing the release of liability and a default position of paying claims that loss or damage to stored property to people or members. And that is a little different than insurance, because insurance is a separate contract. And that service is being provided not by the self-storage operator, but by a separate insurance company. So it's regulated. When it comes to the rent control issue, or these rent control with respect to the declarations of emergency, it would be in fact affected under completely different sections of those laws. Scott, do you have any comments?
Yeah, I'd like to sort of separate out the issue of rent control during a state of an emergency from the separate pressure that you're talking about legislatively to create a control over businesses as to what they can charge their tenants in the self-storage industry for the use of their properties. I have a pseudo constitutional sort of marketplace concern about that I'll come back to in a second. I'm all in favor of the rent controls that we see, these price gouging laws that you're talking about during periods of emergency. And boy, I know you're in California, Carlos. California is unique in many ways as to the frequency of these state of emergency provisions, and therefore the triggering of these price gouging and rent controls over, like as you said, a panoply of industries and consumer goods and commercial goods and things like that. I sort of struggle a little bit even in that concept with why self-storage is specifically delineated within those state of emergency listings, because we really don't have anecdotal evidence of operators suddenly going, wow, there's been a fire in California, let's raise our rates 100% and take advantage of the community. So I don't, it always sort of troubles me that self-storage has been thrown into this price gouging controls when I don't really think they've been guilty of anything.
The self-storage is actually not singled out. They come within the entire storage community. And I think that, and these statutes go back, decades.
Yeah.
And I think the thinking when the statutes were actually passed is that one of the things is that goods and services wasn't self-storage back when these were probably passed, because I think they go back to the 30s. They were thinking in terms of the supply chain and things going into commercial warehouses and that kind of thing. And the idea was to, not have bottlenecks in the system. For good or ill, and just the way the statute is worded, it's pretty hard to argue that it doesn't apply to self-storage.
No, and so it's always troubled me a bit because it suggests that there's bad faith in our operators, and I know there's not. But separate from this issue of just trying to create a statutory rent control, and I'll get to Iris's point about the separation of protection plans and tenant insurance in a minute. But to say to an operator that your rent increases are limited by statute, notwithstanding your increased cost of operation based upon insurance, based upon property taxes, based upon labor costs, based upon utilities. It's that push-pull of an operator in our industry having these increased expenses, but limiting its ability to recapture some of those costs by increasing their rent. And you don't see that necessarily in other businesses. And I understand the residential element of this so that people can find affordable housing, but for self-storage, it's always troubled me. I don't mean to stand on a soapbox, but I think rent control is a scary thought in commercial businesses.
Scott, you're not actually on a soapbox. You're actually in the California legislature right now, because one of the amendments to the initial sort of placeholder bill that was put in was that there would be a CPI factor. So what would happen is the increase would be 10% or 10% plus the effective CPI or something to that effect. And that was under consideration. That has been thought. And Joe Doherty and the Self Storage Association are working on that. California Association are working on that pretty hard.
So in the general context of rent control, and again, I'll get to this issue of protection plans in a minute. We see these rent control bills pop up in other states. So of course, they've been in New York and in other jurisdictions. And I think what we're facing there is a sort of, a confluence of factors dealing with the economy, the relative disposable income of the consumer base for this business, and the operator's behavior of increasing their rental rates in self-storage in our industry. There is a reality that in self-storage, we do see a frequency of rental rate increases. Again, now, not that there's anything wrong with that. These are month-to-month contracts. But because of the frequency, we hear a lot of noise about consumer reaction to frequency of rent increases that have then led to this legislative reaction of rent control. Is that a fair sort of issue concerning why this is all happening in our industry?
To be honest, you're spot on, because the legislator who introduced the bill, wasn't in the shower one day and thinking, I think, what this country needs is self-storage rent control. What happened is he got a constituent complaint. And that is something that especially state legislators listen to. And this particular constituent told this legislature that, I rented a self-storage space, and I got this large rental increase after just 90 days. And unfortunately, things like that can turn into legislation if you're not careful. And it's one of the reasons why, the industry, has to be cognizant of the environment that it lives in. And there may be things that you could do that might maximize your potential revenue for the business, which is what businesses tend to do. But there are times when that may not be the most politic thing to do, and may lead to a unfortunate reaction. And that's what we're seeing today in California.
Yeah. We do have a question I wanted to ask real quick from the audience. Arlie, I hope I said your name correctly.
What was the thing?
She's in Utah, and she asked, do we expect, her question is, do we expect other states to potentially follow California's lead and impose similar restrictions on rate increases in the near future due to emergencies or natural disasters?
Yeah, the price gouging side, the emergency restrictions, I think that's one situation, and I think that's an area, especially as they increase and if they become more severe, I think legislators will be responsive to. I think this sort of generalized thing that California is doing, it could start other states picking up on it. We saw that with late fee regulation. State, I think it was Pennsylvania was the first state that had late fee regulation, and now it's fairly common. So you do have to be careful on these things. But I think that, one of the things that will be out there is an opposition, i.e. the industry. And I think other industries, one of the ideas is to build coalitions with other industries where rent control could be a potential problem where it doesn't exist now. Because, most states don't have residential rent control. A handful of states only have residential rent control, California being one of them. So I think that they would go to residential rent control before they would probably regulate self-storage.
Absolutely.
So let me make sure I answer this and follow up on Carlos's point about the issue of protection plan rate increases against tenant insurance rate increases, and just sort of wrap that in a bow. What is unique about protection plans is they are extra contractual to the relationship between the landlord and the tenant. So when you charge for a protection plan, it is allocated as additional rent. So if the statute controls your rent, it would thereby control your increases both for your rental rate of the use of the space and the additional rent that you may charge for these protection plans. This is much different than tenant insurance, which is governed by rate structures and approvals through the Department of Insurance of your state and would not fall within the same sort of rent control restrictions that Carlos has outlined already. So that's an important distinction. Many operators have protection plans and think that they can unilaterally raise rates on protection plans, notwithstanding a state of emergency status or potential other statutory restrictions. They need to be careful about how they raise their rates.
Yeah. No, I agree with that. And one of the things that you have to be aware of, with both protection plan and possibly insurance is how is protection plan or insurance presented to the customer? because in some instances, and I just saw a facility that does this, it's mandatory. And in fact, it's included on every contract, but can be taken off at no cost to the tenant if they come in within 30 days with proof of insurance. Be aware that how you advertise rents online, that can affect it. If you can't rent a space without adding on $15 for insurance, $15 for a protection plan, then that has to be incorporated in the rent that you show on your website if you're in states like California and Minnesota. And this tendency of states not liking what we call drip pricing is spreading. There's an area where something that started in a couple of states is now where it's being looked at in other states. So just you have to be careful in these things. Not just in something in terms of how you present it to the public. And if you had a different structure on your protection plan or insurance that, oh no, it's an optional idea, you can either take it or leave it, then you wouldn't have to include it in the rent that you put on your website. It's the mandatory. You can't buy without having this. Even the separate contract of insurance, that needs to be disclosed within the rent itself. Now you can line out it later in the process, but you need to show it as part of the rent if you make it mandatory.
Yeah, that makes sense. And we did get another question from Amanda. She's in Florida, and she asked if you know if there's any state of emergency storage rent control currently for Florida. Her area was hit hard by the hurricanes Helene and Milton. And, does it fall under the FEMA Price Gouging Act?
Yeah.
That's an excellent point. I was actually thinking about Florida when Carlos was talking in response to the first question about other states being impacted by these state of emergencies. Absolutely, Florida had price restrictions. Even Georgia, my home state, had restrictions arising from the way the hurricanes came through the state up to North Carolina. They're temporary in nature, but they did occur. And again, self-storage typically falls within these restriction pricing because people seem to go to self-storage after emergencies to store their goods during renovations and repairs. So the answer is yes. Every state has different language concerning pricing during state of emergency controls. Some, as Carlos mentioned, have a 10% or some specific calculable amount that cannot exceed the prior rent before the emergency occurred. Others have a guardrail of making sure that the pricing is not unconscionable or unreasonable. So if challenged on your pricing, your rent increases, someone could say you increased your pricing unconscionably based upon the emergency. The response would be to measure market rates in your area and to show that your price increase was not unreasonable or unconscionable.
Yeah, what Scott's describing, we kind of call it a soft limit. It's not a hard limit like 10% or something like that. And if you look at enforcement of those over the years, they're not 10%. Those things are where a gas station, the day before the emergency charged $4 and the day after is charging $12 a gallon. It's usually pretty extreme, and you've got to be you really got to be pushing the envelope if you're in the ones that have these soft limits where it has to be unconscionable. So follow the lead of you all. After an emergency, they always advertise first month's free.
They do.
And you have to, the one thing to always think about this is that, people think about self-storage as a month-to-month, tenancy, but the average customer stays in their space for 3 years. So it's a better relationship, and it's a more lucrative relationship than you might think based on the fact that it's a month-to-month tenancy.
Yeah, absolutely. And I do want to ask, when it comes to the price gouging laws, how do operators navigate a situation where the cost of their plan increases? Can those costs be passed on to the tenants? Do you have suggestions for them for that?
Yeah, no, the laws all deal with that, but you don't ever want to have to do it. I'm going to put it to you that way, unless you've got a really extreme. They always say unless the business can prove that the higher amount is necessary due to cost and that it incurs, blah blah blah. But the problem with that is the burden of proof is on the price raiser. And as a practical matter, unless you're really getting hit with costs, you don't want to have to sit there and prove that your higher amount was necessary because you incurred higher costs with respect to the inputs.
Yeah. And did you have another comment, Scott?
No, I was just going to say, I mean, I think it'd probably be helpful to move to a different topic.
Yeah.
But because we could talk about this one topic of rent control and price gouging and hidden fee issues, forever. And we want to keep people interested so they come to ISS and SSA and keep asking us questions.
Absolutely. We do have one more question.
Okay, all right.
And this we're going to move on to talking about renovations and tenants. John said he's seen at least one state attempting to stop negative opt-ins, where if a storage owner adds insurance or protection, if the tenant does not produce proof of insurance in X amount of days, is that okay? I'm not sure I'm totally clear on that question, John.
Yeah, I can tell you this. I don't know specific. I don't know if one of these has been passed yet, but it is an area that legislatures are looking at, especially with anything where there's you might think of it as a subscription service, but a whole lot of businesses and things that folks buy that have repetitive monthly charges, and that is where the negative option is being looked at by a number of legislatures.
Okay.
I do know the Federal Trade Commission on this concept of negative transaction, and it goes a lot to the ability to cancel the transaction easily.
Yeah, that's a good point, Scott.
So there's been a lot of discussion. Again, if you think about the sort of shift towards consumer transparency, both on the fee side and on the cancellation of fees and charges, so that there's a lot more clarity and transparency and honesty in the transaction. It goes to the same question of the negative opt-in. It doesn't bother me that there be a negative choice, meaning that you're going to be, unless you can prove immediately that you have tenant insurance, that you're going to be put into our program, but you have the right of opting out if you provide proof. Like Carlos said, sometimes timelines may be up to 30 days after the original rental. As long as that's clear and transparent and the customer understands their rights, that they could opt out immediately if they provide the proof of insurance, I don't have a problem with it. I know legislators are struggling with that. But I think the answer to these anxiety questions concerning operations is to be as transparent as possible on your websites. Have very clear and definitive terms and conditions about your right as a tenant customer to elect one thing or the other. And if they elect to not provide proof of insurance, they understand that as a condition of tenancy, they must be insured, their property must be insured, so they're going to be automatically enrolled in the facilities program. Notwithstanding that, they always have the right to get out if they provide proof of their own insurance.
Yeah, one of the areas that on these type of things where you're required to do something is that one of the catchphrases is that the process of getting out of that type of a service has to be as easy as it is to get in. So it is going to be tricky, I think, going forward if we see more regulation in this area. I think for the time being, sort of the typical model that Scott described, where the tenant can come in with proof of insurance in 30 days and the charge itself is reversed. And then they can come in at any time, usually after that, and the program will be stopped, but that first month they'll still be charged for.
Great. All right. Well, I think we'll move on then to renovations and tenants. So we've seen a lot of self-storage operators deal with facility renovations, while tenants sometimes are still occupying the space. In that case, how should operators handle tenants who are affected by the renovations, especially if they fail to respond to a relocation notice?
Yeah, I'll start the conversation on this. Let's say the typical facility has 300 doors, maybe four, maybe even more. And the recognition that if an operator needs to make repairs or is processing a renovation or expansion of their facility that impacts those tenants, they're going to give notice to those tenants, and in many instances require those tenants to move from the building they're in to another location, maybe a nearby facility that the same operator owns, and they want to help relocate them or something. But it involves the tenant moving out of their rented space. So we all know that that's a physical act of returning to the facility, gathering your property, relocating it, or vacating from the facility. So it's not easy. But a tenant who, I'll phrase it, is lazy to not respond to a landlord's notification that they have to move because the building's being renovated or repaired is not a defense to a tenant who needs to respond appropriately to the landlord's directive. Again, these are month-to-month leases. So there has to be a solution for a operator, landlord, to relocate a tenant who is non-cooperative, non-responsive, maybe even defensive or militant about the fact that they refuse to leave. And that's why we wanted to bring up the conversation to create solutions for operators when they're in these defensive positions with their tenants. These are operators that need to do things for their facility, but tenants who stand in the way.
Yeah, and I always, when you're dealing with a situation like that, you need to do something with respect to the facility. In this instance, make repairs to, perhaps all of a building or part of a particular building. And in order to facilitate that, you need tenants to move out. And sometimes there's other spaces within the facility that people can move to. But, always take a look at your rental agreement, because the rental agreement usually gives the operator significant rights when it comes to, facility repairs. And that the tenant, if requested to do so, and again, is it moving to another space? Is it moving to another facility? Or is it, we just need to end this tenancy because we're going to be working on this project for several months? The tenant, in a sense, can't hold the operator hostage. I think one of the good things, a best practice idea is when you're contemplating this, bring the fact that you're going to have to relocate customers early in the process. Because if you want to give yourself and you want to give the customer some time, and can you usually do this? If you look at the rental agreement, it'll usually say something like 30 days notice or something like that. Or in some instances, an emergency situation or some types of situations, essentially very little notice, 48 hours and no notice. But again, you want to give the process some time to work. And so if you can, let the tenants know that, we've got to do this. We know it's an inconvenience, but we've made some arrangements to make the process easier for you. And you're usually going to give them a date why, you really need to be out by this date. And so we can make arrangements to start fixing it. Give yourself another 15, 20 days past the the date you're telling them before you reach a drop dead date, because you're going to have to take some steps that you probably don't want to have to do when you have to, actually go in the space, take their property and move it. Pictures, video, make sure you record the record and keep the tenant informed. Even though these are tenants who are causing you problems, one of Scott's favorite words, transparency. And this is an area where you want them to know what's happening and why it's happening.
Yeah, absolutely.
Are you getting results of your poll? I'm curious before I add comments here.
We have, no, I've never had to relocate tenants, says Richard. We had Kelly said yes, but it was challenging. So that would be what I would imagine if you said yes, it was probably challenging no matter how well you prepared for it, right? But, I think Carlos gave some great practices, especially when you just kind of give yourself an extra 20 days from your hard deadline.
Yeah. Well, yeah, absolutely. You need the additional time. Let me add some additional recommendations for the process. Is that first notice can be the clarification of the repair or renovation that's going to happen and the request for the tenant to move. If they don't respond or they're being difficult, look, there's nothing wrong with helping cajole your tenant to cooperate with rent discounts, with provision of adding additional dumpsters to the site to assist in maybe a vacate or disposal, having movers at the ready for people that are otherwise physically unable to move their property. We have certainly an elderly population that use self-storage. It's not so easy to move out, so they may want to, but can't. There may be other tenants that financially can't afford to hire a truck to move their stuff. So, the operator would have its trucks available for free rental to help move the property. You have to be thinking about the cooperative effort to get the tenant to do what you need them to do for the ultimate prize of getting your property free and clear to do the renovations that you want to do. And then ultimately, and Carlos is too nice to say this, but I'm just going to use the word termination.
Yep.
At some point, if you just have a tenant, and I use that word militant, who just refuses to leave and threatens whatever they're going to threaten about you going in and removing their property so you can perform the repairs or renovations that you need to prepare, you may have to go through a lease termination. You may have to go through an eviction process. There are solutions. There are ultimate solutions for an operator dealing with a recalcitrant tenant that refuses to vacate. But at the end of the day, as long as you don't dispose of the property, but relocate it, as Carlos said, with photographs and inventory as a temporary move before the eviction may happen, that the disposal may happen, or the lien sale may happen for non-payment. You don't have to wait for the process to be ultimately completed before you perform the renovation or repairs that you need to make.
No, one of the things that I've found has happened in a lot of these situations, this has been in connection more with facilities that are actually closing, or there's been a eminent domain action on a building or something like that, where they're actually getting the rule of thirds seems to work pretty well. And that is, if you send out your first sort of, this is what's going to happen, and this is sort of the date we need you to get out at, 2/3 of your customers will probably do it without a problem. And then there's that other third, and 2/3 of that number will probably comply with a little bit of a push, a little bit of, let's call it customer care, you really have to leave kind of thing. And then you're going to be hopefully left with what we call the few stragglers. And it may, even if you're dealing with, 30 or 40 spaces, when you get down to the end, you're hopefully dealing with less than 5, where you really have to take what we might call a more drastic solution to the problem and actually move the problem. One of the things that, like in the situation we're sort of been talking about, is they're doing repairs. And they kind of want to keep those tenants around so they can put them back in those storage units and not have to just put them, re-rent all of those spaces cold in a more challenging rental environment. So customer care can make sense at times, especially if you'd like to be able to do the repairs, get it done, and get those same tenants back into those spaces.
Certainly. And we're all, and we live in an age where Google reviews are key as well. And you don't want that angry tenant to go in and start splashing 1-star reviews because you didn't help them move the day before they were supposed to move.
I'll add one other thing is on the topic of termination. The refusal to vacate after notice would fall into what I'm going to call the non-monetary default under the lease, by the landlord notifying the tenant they have to leave, and then they refuse to leave, and that they would notify them that they've therefore, because of the right of the landlord to reclaim the space and the tenant's refusal to leave, it's not a monetary default, non-monetary default. Now you see a number of states that would permit a series of notices after the termination to require the tenant to leave, and in lieu of a judicial remedy arising from that default, would be a self-help remedy of disposal of the property. I'm not here to suggest anyone start thinking about throwing out their tenants' goods, but there would be some path towards using the self-storage statute for the tenant's breach after notice to use the termination, self-help termination provisions that we're seeing being added to self-storage statutes and leases. Carlos, you okay with that?
I love it. And I'll tell you why. This problem of a tenancy ending, bad tenant, something other than rental problems, though. They loitered on the premises. They did things that threatened other customers, threatened a site manager. There was just it was time for the relationship to end. And in California, that led you to the courtroom, because there was no, the lien only dealt with non-payment of rent. It didn't it didn't solve the problem of when a tenant was ready, willing, and able to pay the rent. But you just didn't want to have the relationship continue. And the change went into effect on January 1st. And it's been a game changer. It changed the dynamic that storage operators have when they have tenants that they where they've ended the relationship for any variety of reasons other than rental issues. And rather than a judicial solution, which took months, maybe longer, cost a lot of money because you had to have a lawyer who specialized in what we call unlawful detainer actions. But even unopposed, these things, the legal fees would run $2,500, $3,000. I mean, it wasn't cheap. And time, you lost time and you had a problem with the space. The new remedy executes within, well, about 45 days at the longest. And actually, if the property is of little value, it can all be wrapped up in less than 30 days. And that is a change for the better.
Definitely. We did have a quick question from Amanda, who said, what if you had an emergency? Well, it wouldn't really be an emergency renovation, but let's say a repair. Do you have any quick suggestions on that? I mean, if it's an emergency, obviously.
Oh, I had an emergency just recently. Roaches and mice.
Oh.
Unbelievable numbers, all emanating from a single space. And the problem was that the tenant had stored large amounts of accessible food and food that was not keeping very well on top of everything else. And they brought in an exterminator. And the exterminator said, "You got to get that out of there." And that was an emergency. And I think they basically told the tenant, "If you're not here by such and such a time today, this is what we're going to do." And I think they just sent the email out because they couldn't. This was an extreme situation. I was talking to one of the folks that worked there, and they'd been in the industry for 18 years, and they said, "I've never seen an infestation like this."
Oh, that sounds
And she
awful.
said, "I've seen some pretty
Really
bad."
emergency. I agree. So they just sent an email and went in ahead and did what they needed to do.
Yeah, they needed to do it. I said, "Look, you got to do and just follow what the exterminator. You've gone to a professional. They know it needs to be done." And I told them, take pictures. Whenever you open a space, take pictures, do video. But other than that, follow follow what the professional tells you needs to be done, and you'll be okay, because that's the only thing you can do in a situation, because that's a health and safety issue. It's also has the potential of affecting other tenants. It affects the entire facility, and it can't be allowed to just linger.
I have to laugh with the
Right.
emoji that Airly used. That's why we don't allow food storage in our properties, with that little mouse. And I almost want you to take it down like immediately, because that mouse is freaking me out. Like, that's the worst thing that can happen in a self-storage facility. And I know operators work so hard to control, but you can't dictate and oversee exactly what everybody puts into their self-storage unit. So we see this problem a lot. It's sort of a separate topic. We could talk about rodents and food, another. Let's save that for another topic, because that's a whole different series of.
You're going to talk about dead snakes?
No. Let's move on to rental agreements.
Well, what Arlie said is we don't allow food storage on our properties, and so that leads us right into our next segment, which is rental agreements. Should we be putting that in the rental agreement? We should be adding it in. And
that's a soft toss to you, Carlos. What would you put in your use provisions in a self-storage rental?
The use provision, the use of space. You usually want a self-storage space has one use, and that is dead storage of non-perishable property. I want to emphasize the non-perishable. So you don't want people opening up retail shops inside their storage unit. But, there's a number of things you don't want them to store. And the obvious ones are things like gasoline and things like, explosives and a variety of things that could harm the buildings. You don't want them to store food, obviously, because food, as we know, can attract critters. But there's quite there's just a sort of a common sense list of things that really don't belong in a self-storage unit. And so, restrictions on these, always keep in mind, it's your property, and you can set reasonable restrictions on how that can be used. And how it can be used is in the name of your business. It's self-storage. It isn't self-workshop. So just keep those those things in mind. And that leads us into perhaps the most, at least in my mind, one of the most important limitations on what tenants can store, and that's the value of the property. Iris told us, we really don't know what people are putting in those spaces a lot of the time. And, but you might want to have a little bit of control over the value, or at least control that you're willing to raise if the tenant tells you, well, we're having our home remodeled and we're putting 3 rooms of furniture in this place, and we need a higher value than what is typical $5,000. Then that could be done by an addendum. But But the $5,000 limitation of value, in my mind, has been one of the most important provisions that operators put in their rental agreement. I have no problem of site personnel having an addendum where they might increase it from $5,000 to say $10,000 or something like that. You know, if a tenant wants to increase it in $50,000 or $25,000, you might want to tell them, we need to have a conversation about insurance and how this property is being insured. But you really do need to be able to control the value that goes in those space, because it also controls the aggregate value of the property that might be in your facility. And it gives you some idea of what you might need for customers goods legal, which is a pretty important insurance coverage for this industry. Scott, you deal with the limitation of value in court. How are you doing with that?
Yeah, no, I would agree with you, Carlos. In terms of a essential element of a rental agreement, clearly the contractual provision dealing with the fact that the contract is a non-bailment contract, that it's self-storage, that the facility does not take care of custody and control. And arising from that non-bailment clarification comes two important provisions. One, this limitation of value, because again, the operator does not know what's in the unit. It'd be unfair to put the burden on the operator to be exposed to unlimited liability when all they're doing is renting the space for storage to the tenant, and for the tenant to maintain its care, custody, and control of this property they store. They know what's in there. They know how to value it and have to declare if the value of their property exceeds the contractual value. And the third piece of that is this shifting of risk of loss that the tenant maintains to make sure that the property that they're storing is insured. And that's the tenant obligation and responsibility under the contract to insure it or protect it under what are now these new protection plans, these contractual protection programs. Those three elements, again, non-bailment, limitation of value, and shifting of risk to insurance, to me are the skeleton bones of a important rental agreement. Of course, the next piece being the statutory requirements set by the state self-storage law that then are imposed on each individual lease under that state as to what language needs to be in there, what font size needs to be in there, what emphasis there needs to be in terms of capitalization or underlying what required language, things that Carlos has been at the forefront of for all these years. And I'll yell at you, Carlos, is that how is it possible that notwithstanding all of this effort to create a model law that each state would follow and would be similar, that you could have 50 state laws? Well, we'll talk about Alaska in a second. 49 state laws, District of Columbia, Puerto Rico, and they all be different.
UCC, every state, uniform law, and every state has its own variations within the Uniform Commercial Code. And when you're dealing with what you try to do is you want a certain consistency, let's just say, about the law. States invariably want to go their own way, and it's something that is kind of within the law is hollowed as the UCC. Even they can't impose their will on the state legislatures. So you try, but you're never going to succeed. I do think that Scott brought up one thing that was interesting. Is we have this tripartite. I always looked at at owner liability, at least with respect to the rental agreement. You know, there are three really potentially effective defenses within your contract. One is, as we've already discussed, the value limitation. Two, insurance. There's a basic principle: if a party agrees to insure, to provide insurance, and a loss occurs, that would have been covered by the insurance within a contract, that would bar a suit against the counterparty for that loss, even if they might be negligent or something like that in causing the loss, because the failure was the breach of contract, not buying the agreed upon insurance or something like that. And the last is the release of liability. And early on in the industry, one of the things that I had found is that I at one time I oversaw self-storage claims all over the country, and we did, there wasn't a lot of litigation in the 80s and early 90s, but there was enough. And one of the things you would find is that judges were like trout. You never quite knew what kind of bait they would bite on. And you could have a judge. I'd get these stories from the lawyers. He just excoriated us because of the release of liability in the rental agreement. How he's not going to enforce something like that in this contract, but he enforced the limit of liability. Or he said they couldn't collect because they were offered insurance and they didn't buy the insurance they agreed to buy. And he said, you just never can tell. And so that's why you have these three provisions in the rental agreement, is because the judges are not consistent in the kinds of things. Any given judge might love a limitation of liability. Another one will say, I'm never going to enforce that. But yeah, if you have a limit on the value of property, that's obviously enforceable because anybody can understand it.
Right. Yeah, definitely. And I'll end that with Floor asking, and I think we are all going to be unanimous on this, if we make changes, do we always need to have it reviewed by an attorney? Let's say they go to see you at ISS or SSA, Scott, and they follow the suggestions you give during one of your presentations. Should they still have their rewrite reviewed?
Well, I think rental agreements, being a contractual terminology, inevitably would want it to be reviewed by an attorney only to the extent that if it's ambiguous at all, it creates conflict. So the more eyes you have on it, the better. I would not say that there's magic language that a lawyer can provide to these rental agreements. It's their just interpretation and experience what language works best, unless it's statutory language, which has to be included in the rental agreement. I'd like to say, after doing this for almost 40 years, that the counsel I've provided has been valuable to my clients. But they can do what they want. I've seen plenty of rental agreements that were written by operators that were sometimes brilliant.
Yeah, it's a funny thing. I mean, one of the things that you do with a rental agreement is you're almost drafting something for a bad relationship. But on the other hand, most relationships in self-storage are pretty good. Tenants rent a storage unit, they put some stuff in it for months, sometimes years, and eventually they move out, and nothing really particular happens during that period of time. The roof doesn't leak, nobody breaks into the storage unit, the tenant doesn't have a slip and fall while they're taking stuff into their storage space. It's a fairly benign relationship, and that's something to always keep in mind when you're dealing with a contract. You have to prepare, for a potential of conflict. But the odds are the relationship's going to work out pretty well in most instances.
Absolutely. And I think this is a great time for a shameless plug about the Self-Storage Legal Network. So if you do have questions, or you can. If I'm a member of the Self-Storage Legal Network, could I submit some of my updates? Would they review those for me?
Well, no. I mean, the SSLN provides legal information to its subscribers, so we could provide information regarding the statutory requirements. We could provide some information concerning the recommendation of language. that could go in the agreement. But if you need your rental agreement reviewed and approved by counsel, that would be, unfortunately, that's outside the self-storage legal network and would be, you would separately retain counsel for that service. But we are available, and we're very proud of the legal network being available for operators to ask questions, and we can provide the legal information to guide them to the solutions to their problems. And it may ultimately be a situation where they need to retain local counsel to assist them. But the answer may be found in the statute, or the answer may be found based upon the experience of other operators of how they've solved those similar problems that we're familiar with, that we can guide those the subscribers to those solutions.
Yeah. One of the things I think that is important when you're doing your rental agreement, and why a certain amount of customization and maybe working with a lawyer is a good solution, because you can buy, rental agreements off the shelf. I mean, they're available out there, and printed forms or online or whatever. Is that the rental agreement needs to reflect how you operate your self-storage business. And if you get and it may be a small thing, if you get a rental agreement that says rent is due on the first of the month, and you have an anniversary system, you've got a problem on a very fundamental thing. So again, it does need to reflect the way you operate the business. And there's a whole lot of things that, a number of things that storage operators do that may not be just like the guy, down the road does. You might have different late fees. You might have different lien charges. I mean, there's just a variety of little things. And so make sure that when you read that rental agreement, and the most important thing is when you read it, it describes how your self-storage business is operating, because that's what that document is all about.
Absolutely. Well, on that note, we are right at our time limit today. I want to thank you both so much for joining us. I'm going to be bringing Aaliyah up in a second. I do want to let everyone know, if you registered today, you can watch the replay on YouTube. It'll be available. You'll get a link, and Mari will send you something with any resources that we have to send out. And Aaliyah is putting it in the ticker for me. You can see Scott speak at Inside Self Storage in Las Vegas coming up in a couple of weeks. He'll be talking about dealing with. Oh, she took it down too fast for me to read it.
Well, Scott had a question, and he wanted to know, did he participate enough to get the Starbucks coupon?
I already told Scott I was going to buy a drink in Vegas. You can come to our party. Carlos, you're going to miss out. Scott can your drink too, Carlos. So, I'll get him a coffee and a drink. Your choice. Or
sold. Iris, I wanted to thank you guys. I noticed the cartoon image of Carlos and I at the beginning of the session. So you took me up on my request that somehow the caricatures of Carlos and I survived to match your little insignia over there with the keys in your hand. I think that's great.
Yeah, we'll have to. I'll have to memorialize that somehow, but we'll keep it going. And that was the perk of having an extra hour to get ready this morning, as I could go in and create a little Scott and Carlos characters. I love it. We'll definitely use those again. But yeah, everybody go and see Scott. He'll be talking about dealing with tenant stuff at 10 a.m. on April 24th in Las Vegas at ISS. Don't miss it. And I'm going to say farewell to the both of you. Thank you so much for joining us today. It's always a pleasure. And we will see you again soon. I'm going to bring Aaliyah up, and she is going to talk about who our winner actually was today. Hey, Aaliyah, how are you?
Hello, I'm doing awesome. That was such an informative session, Carlos, Scott. Thank you so much. I think the comments were showing we had a pretty good time, a lot of really good questions. So thank you, everybody, for participating today.
Absolutely. So I think there was a pretty stiff competition for that gift card today.
It's always a teeter-totter. It's always a teeter-totter, but we do have a winner.
Drum roll. Wait. Here we go. Yeah. Ari.
Yes, around Arlie. I'm so sorry. I would love to, if you could spell that phonetically for me in chats.
Yes, let us know.
Let me know, but you are the winner.
Sure.
We're trying our hardest. You are the winner. You are the winner. So I'm just going to put the instructions here. See it on our little banner at the bottom. And if you send an email to mari@thesboa.com with the subject line SU winner, we'll get you that gift card today. Thank you so much for participating.
Yes. And Amanda, we will be putting that into the chat for the Self-Storage Legal Network. I saw that you would like more information about that. So we're going to make sure you get that. And so, Aaliyah, do you want to tell everybody about what's coming up? We have a lot going
Absolutely. We do. I mean, it's trade season. There is always so much going on. First things first is I'm going to plug I'm so sorry, I'm trying to find it here. I'm going to plug our events page so that you can keep up with us and you can see where we're going. Details are likely to change because you know how it is in trade show season. So keep an eye on this. The next event that we're going to be at, of course, is going to be Inside Storage for the World Expo in Las Vegas. You can find us at booth 346. We have so much going on, from a dinner in the tower at the Strat with the best views in Vegas. I'm going to put my money on it because it's the gambling city. So you know how it is. We're going to be meeting at the Top of the World restaurant. It looks like a really cool event, guys. We're going to be bringing vendors, we're going to be bringing our VIP members. So you're going to want to make sure that you are, in fact, a VIP member. You can get your membership today at thesboa.com/membership. Like I said, you have to be on top of it. If you want to get that notification, the invitation for them, if you're attending, become a member. You'll be added into the invitations that are going out shortly, and you'll get all the details. So I'm really excited for you guys to see that. But if you can't, even if you're not a VIP member, you should stop by our booth because our team over in SBOA Insurance Services is going to be joining us. And they're holding and hosting a drawing for a $2,500 Visa gift card. Rules and restrictions apply, of course. You follow the rules and you get through, you'll be in the drawing. So you're going to want to be there. You're just going to have to submit a commercial insurance quote in completion. Keep your eye out on an email. You'll be getting a follow-up from one of the team members at SBOA Insurance Services to finalize your steps. But once you're in, you're in. So really easy, a quick $2,500. I'm not going to complain, So make sure that you stop by, see us. People came to see us at SSA Orlando. I think she might be in here. I think I saw Carrie for a few seconds, and it made our day to see you guys in real life. So please come see us. Please, please, please. But I think
I do want to reiterate that in order to get that Visa gift card, there's drawing for one. You don't get it just for submitting your request for quote, but that is how you get into the drawing. So you can even see our QR code there. Maybe if we take the ticker down, you can see it a little better. But yeah, so make sure you stop by the booth, but you don't even have to wait for the booth. You can actually sign up now. And you don't, even if you're not going to Las Vegas, you're not going to be at ISS, we have that opportunity available to you. And we have one more announcement about ISS. I'll let you go ahead, Aaliyah. We're going to have our new team members. Yeah.
You guys are going to love her. Michaela, she is our marketing assistant, and she's going to be joining us at ISS for her very first trade show, her first introduction to the self-storage industry. And she's going to be taking professional headshots for our VIP members, vendors, and friends. So you're going to want to stop by. We might put a camera in your face and get some content for the socials that I'm working on. So, come by, please help me out. Let me get your inside look at self-storage operators, owners, members, vendors, and everything alike. I want to see where everybody's at in the self-storage industry and give everybody a warm welcome to Michaela because you guys are gonna love her.
Absolutely. And, hashtag welcome Michaela. You had that come up.
That needs to be next trending.
So yeah, just watch your social media, watch your email. You'll see more and more about everything, all of the details rolling out. I want to reiterate one more time that if you are a VIP member, that is how you get the invitation to our dinner. Those have become so popular. They sell out very quickly. And just because you get an invitation does not mean you have a seat. You have to go in and register for it. You have to answer the RSVP. Because we only have around 60 seats available. So we have to get you in there. And then we'll move on and just talk about our next webinar. That is going to be with Da Vinci Lock in 2 weeks. So that is April 17th. We'll resume our normal time, which is 11 a.m. Eastern. And they're going to come in and talk about how to drive profit. Da Vinci has all kinds of great new products. I just watched one of their webinars a week or so ago, and I can't wait to hear more about it.
Me neither. It's going to be a good one. 10 Federal's joining in. Andrew Capranos from 10 Federal will be there. It'll be a good conversation. Switch up from this one, but we're constantly switching it up. So you're going to want to stay tuned for everything that we put on this year.
Absolutely. And on that note, we did forget to mention, and I have to add that to our graphic. Joining us at our booth at ISS will be Dan Cosgrove and his beautiful wife, Val. And they run our mystery shopping and internal audit programs. They are going to be there. If you have any questions about mystery shopping or internal audits, they are there to answer your questions. They have an amazing new product with mystery shopping that relates to AI, but we're really going to be focusing at ISS on the internal audit program, which is going to make your processes and procedures so much easier with your business. So we are going to end on that note with a little video that talks about our internal audit program. And I want to thank everyone for coming out today, especially those final people who hung on with us for the last 10 minutes of going over our time. And I hope we see you all in Vegas. Have a great day, everybody.
Have a great one.
In a world where brand experience is paramount, upholding your company's standards demands unwavering consistency in every location. At the SBOA, we understand the critical role consistency plays in driving your business's success. That is why we joined forces with MSI to introduce a revolutionary internal audit program tailored to meet the specific needs of your organization. Our game-changing audit program leverages cutting-edge technology and expert insight to bring you unparalleled accuracy and reliability. We know that success in this competitive environment is paved with adherence to operational requirements, and every company has its own standards along with state and local regulations to adhere to. So we've made our internal audit system completely customizable, all in a user-friendly app. The app enables on-site agents to collect real-time data and insights from their respective locations. This feature ensures that information is up to date and allows for quick responses to any issues or challenges that could arise. Our internal audit program also has advanced photo and video reporting capabilities. These visual reporting tools allow leadership to visualize non-compliant sites and gain a comprehensive understanding of the issues, with specific examples for clear context, which enhances communication and leads to faster resolutions. And it can be done with just a few clicks and the snap of a photo or quick video. And our program provides an in-depth understanding of each store's performance and challenges. This feature allows for a comprehensive assessment of how well each location adheres to operational requirements and brand standards, helping to identify areas for improvement. Are you ready to take your self-storage business to the next level? Explore our comprehensive suite of services, including internal audit programs, mystery shopping, and unlock your full potential. Contact us today to embark on a journey of excellence and success. 248-254-9000.